So let's talk about sensitive information, because really that's what HIPAA and FERPA are all about. So sensitive information can exist in various forms: printed, spoken, electronic. The main thing to remember, no matter where you are, no matter where your intern works, if they work in your practice or they work at an agency, it's the responsibility of every employee to protect the privacy and security of sensitive information in all forms. So some examples of sensitive information are pretty obvious. So things like Social Security numbers or credit card numbers. But if you look at the rest of this list, driver's license numbers, personnel information, research data, computer passwords, individually identifiable health information, sole possession records, and education records, many of your interns won't understand that these things are also sensitive information. So if they have access to other patient files, or if they have access to education records, everything is considered, in these categories, are considered sensitive. So the improper use or disclosure of sensitive information presents the risk of identity theft, invasion of privacy, and could cause harm and embarrassment to staff, clients, and the practice. Breaches of information and privacy can also result in criminal and civil penalties for both the practice, the agency, and all of those individuals who improperly access or disclose sensitive information, as well as disciplinary action for those responsible. And since you, the supervisor, are responsible for the clients that your intern is seeing, you're responsible if there's a breach and it's determined that your intern was the cause of that breach. So every practice employee, resident, and practicing professional must protect the privacy and security of sensitive information. So let's talk about HIPAA privacy and security rules. The Health Insurance Portability and Accountability Act of 1996, also known as HIPAA, is a federal law designed to protect a subset of sensitive information known as Protected Health Information, or PHI. In 2009, HIPAA was expanded and strengthened by the HITECH Act, which is the Health Information Technology for Economic and Clinical Health. In January of 2013, the Department of Health and Human Services issued a final rule, called the Final Rule, implementing HITECH's statutory amendments to HIPAA. The deadline for compliance is September 23, 2013. All of that to say, HIPAA is constantly growing. It's constantly changing due to technology. It always seems that we're just a little bit behind keeping up with technology and privacy. So don't feel bad if you feel like you aren't quite up to speed on all of the rules having to do with HIPAA and technology. FERPA is a federal law that protects the privacy of students' education records. And you can go to those documents there to see exactly what that is. FERPA applies to educational agencies and institutions that receive funds under any program administered by the U.S. Department of Education. This includes virtually all public schools and school districts, and most private and public post-secondary institutions, including medical and other professional schools. If an educational agency or institution receives funds under one or more of these programs, FERPA applies to the recipient as a whole, including each of its components, such as a department within a university. So in this module, you will be looking at some documents, some pretty lengthy documents, to help you understand the differences between HIPAA and FERPA. So I made this so that you can refer back and have a little bit more of kind of the Reader's Digest version to make it clearer and also easier to teach your interns. So in most cases, the HIPAA privacy rule won't apply to an elementary or a secondary school because they are either one, not a HIPAA covered entity, or two, they're a covered entity, but they maintain health information only on students in records that are by definition education records under FERPA and therefore not subject to the HIPAA privacy rule. So there are some circumstances in which an elementary or secondary school would be subject to HIPAA, such as where the school is a HIPAA-covered entity and is not subject to FERPA. So a school that's not subject to FERPA and is a HIPAA-covered entity must comply with HIPAA privacy rules with respect to any individually identifiable health information it has about students and others to whom it provides health care. So if you can imagine a school that houses a clinic, right, where doctors come in and they provide mental health care or medication care. Or you can imagine a school within a residential treatment facility or a facility where they're providing medical care, but the school is a part of the residential treatment center. You can see how this could start getting a little confusing. The two types of sensitive information that we're going to cover in the next couple of slides are PHI and educational records. So we'll define them and then explain a little bit more about them. So PHI defined, PHI is generally defined as any information that can be used to identify a patient, whether living or deceased, that relates to the patient's past, present, or future physical or mental health or condition, including healthcare services provided, and payment for those services. Covered entities have a duty to protect PHI. So what's a covered entity? It's any person or organization that furnishes, bills, or is paid for healthcare services in the normal course of business. Pursuant to HIPAA, individually identifiable health information collected or created by a covered entity is considered protected health information, or PHI. University departments that use or disclose PHI are governed by HIPAA requirements. Education records, on the other hand, it's a little bit broader. So the term education records is broadly defined to mean those records that are directly related to a student and maintained by an educational agency or institution, or by a party acting for the agency or institution. So at this elementary or secondary level, a student's health records, including immunization records maintained by an education agency or institution subject to FERPA, as well as records maintained by a school nurse, are considered education records subject to FERPA. In addition, records that schools maintain on special education students, including records on services provided to students under the Individual with Disabilities Education Act, or IDEA, are education records under FERPA. This is because these records are 1. Directly related to a student, 2. Maintained by the school or a party acting for the school, and 3. Are not excluded from the definition of educational records. Remember, PHI will be used by any entity that furnishes bills or is paid for healthcare services in the normal course of business. So a school nurse would not fall under that category. So let's talk about parents and education records. At the elementary or secondary school level, students' immunization and other health records that are maintained by a school district or individual school, including a school-operated health clinic that receives funds under any program administered by the U.S. Department of Education, are education records subject to FERPA, including health and medical records maintained by a school nurse who is employed or under contract with a school or school district. Some schools may receive a grant from a foundation or government agency to hire a nurse, notwithstanding the source of the funding. If the nurse is hired as a school official or contractor, the records maintained by the nurse or clinic are education records subject to FERPA. Now, I know we're not talking about nurses, we're talking about counselors, but you're going to see why this is important in just a minute. Parents and eligible students, students who have reached the age of 18 or attend a school beyond the high school level, have a right under FERPA to inspect and review these health and medical records because they are an education record under FERPA. So you can see for your interns who are working in a school, or your interns who are, no matter where the funding, whether it's a public school or a charter school or some kind of a hybrid of the two, this can get really confusing. Now we get to the part of the presentation that really pertains to counselors, the sole possession exception. Not all of the information collected and maintained by schools and school employees about students is subject to the access and disclosure requirements under the Family Education Rights and Privacy Act, or FERPA. There are 5 categories exempt from the definition of education records under FERPA. They are records made by teachers, records made by supervisors, records made by counselors, records made by administrators, and records made by other school personnel that are kept, and this is the key, in the sole possession of the maker of the record and are not accessible or revealed to any other person except a temporary substitute for the maker of the record. Now, for your intern who is a school counselor case notes are sole possession records and not education records, which parents are entitled to see if those records meet very specific criteria. 1, they are a memory aid. 2, they are not accessible or shared in either verbal or written form. 3, they are a private note created solely by the individual possessing it. And 4, include only observations and professional opinions. One of the readings in this module is about a case where an Alaska school district used this to defend itself. So this is really important to know if you plan on supervising an intern in a school setting. In case we forgot, here's another list of sensitive information. So now we've really broadened it here. We've gone beyond Social Security numbers and credit card numbers. Now we have things like biometric identifiers like fingerprints or voice prints, device identifiers, any other unique number, code, or characteristic that can be linked to an individual. I know some of us, we think we're pretty tricky because we come up with codes, or we ask our interns to communicate with us in a way that we think obscures identifiable information. But if you think about in a small town, or if your intern is working with a high-profile client, it doesn't take much for any communication to reveal sensitive information. So remember what we talked about in our first slide. It is everybody's responsibility to protect sensitive information, whether it's PHI or educational records or sole possessory records. So a quick review. Sensitive information exists in many forms: printed, spoken, and electronic. Sensitive information includes all of those things, including education records, sole possession records, and PHI. And there are a number of state and federal laws that impose privacy and security requirements, including the Texas DSHS LPC code, LMFT code, Texas House Bill 300, Chapter 611, FERPA, and HIPAA. Now, when can sensitive information be disclosed? Well, these are just some examples. Employees may not otherwise access or disclose PHI unless HIPAA regulations permit use or disclosure of PHI 4, and you can see the list here. This is for medical records, so providing treatment, processing payments, conducting business operations. So that could be staff members who are going through files. It could be if you have a statement in your disclosure that upon your death or the termination of the practice, this could be the person who becomes the custodian of your records. If the patient has given written permission or release of information, if it's within the scope of the employee's job duties, improper procedures are followed for using the data in research, or it's required or permitted by law. And as I mentioned earlier, Texas has Chapter 611, which details the exceptions to confidentiality and not disclosing protected health information. So if you are not from Texas, now would be a great time to go and review those rules that your state has regarding protected health information. Note, the final rule, remember that from our slide earlier, now protects the PHI of a deceased individual for a period of 50 years following the death of that individual. Disclosures of educational records. Generally, schools must have written permission from the parent or eligible student in order to release any information from the education record. However, FERPA allows schools to disclose those records without consent, much the same way protected health information can be disclosed. Again, Texas has Chapter 611 that goes through all of the exceptions and for disclosing protected health information. So if there's a legitimate educational interest, other schools to which a student is transferring want the information. There are specified officials for audit or evaluation purposes, appropriate parties in connection with financial aid to a student, organizations conducting certain studies for or on behalf of the school, accrediting organizations, to comply with a judicial order or lawfully issued subpoena, appropriate officials in cases of health and safety emergencies, much like the conditions for releasing protected health information, state and local authorities within a juvenile justice system pursuant to specific state laws.